You know, whenever I hear the acronym RICO, my brain immediately goes to the movies.
Well, yeah.
I'm picturing The Godfather, I'm picturing Tony Soprano, guys in tracksuits meeting in the back of a pork store.
Right. It's the Racketeer Influenced and Corrupt Organizations Act. It was literally built to take down the mafia.
But today, we are talking about a RICO case that has absolutely nothing to do with that. There are no tracksuits here.
No.
Instead, we have maybe the strangest alliance I've ever seen. You have Uber and FedEx, two massive corporate giants teaming up.
A team up you just don't see.
And they're suing a personal injury law firm, a doctor, and a chiropractor in Philadelphia.
And the target isn't a crime family. It's a law firm called Simon and Simon. The allegation isn't about loan sharking. Uber and FedEx are saying this firm is running what they call a conveyor belt of fraud.
The conveyor belt. I mean, what a visceral image. We are basing this entire deep dive today on one massive document. It's the first amended complaint filed in federal court in Pennsylvania.
It is a dense read.
It is. I spent my weekend with it, and the level of detail it's just staggering. It reads like a blueprint for a factory, but instead of making cars, they are allegedly manufacturing lawsuits.
$1 million lawsuits. And they're doing it, allegedly, out of minor fender benders. It's a whole scheme. Lawyers, doctors, imaging centers, all of them working together.
So our mission today is to basically reverse engineer that machine. We want to figure out how you take a minor bump in a parking lot, a tap where the airbag doesn't even deploy, and turn it into a $1 million legal demand.
And according to these documents, you do it by practicing medicine without a license, faking records, and performing what they call simulated surgeries.
That word simulated, that's the key, isn't it?
It's the linchpin of the whole argument. The idea that the medical care wasn't real, it was theater, it was all a performance just to generate paper.
Which is terrifying. But before we get to the fake surgeries, and trust me, we will get there, we have to set the scene. Why? Why build this whole complicated machine in the first place?
It's a great question, and it all comes down to a specific quirk in Pennsylvania car insurance law. It's called limited tort.
Okay, let's unpack that. I know insurance terms can make people's eyes glaze over, but this is really important.
Think of limited tort like buying a basic economy airline ticket. It's cheaper.
Right.
But just like basic economy means no carry-on, limited tort means you give up certain rights. Specifically, you give up your right to sue for pain and suffering, what they call non-economic damages.
So if I have that insurance and I get rear-ended and my neck is a little stiff, I can get my medical bills paid, but I can't sue for $1 million just because I'm stressed about it?
Exactly. You're capped. Unless, and this is the loophole, this is everything, unless you can prove you have a serious injury.
A serious impairment of body function.
That's the magic phrase. If you can prove that, the cap just blows right off, and you can sue for everything. The allegation is that Simon and Simon built a machine specifically to get around that cap.
They needed to turn worthless claims, bumps in a parking lot, into serious injuries on paper.
Right. If they don't break that threshold, the case is worth peanuts. If they do, it's a jackpot.
So how did they get people into the machine?
Well, the complaint says they were incredibly aggressive. They marketed themselves to take referrals other firms wouldn't even touch. And once a client signed on, the pressure was on.
I saw that. It says clients were basically told that if they didn't treat with the firm's preferred medical providers, the firm would drop their case.
Preferred providers. You have to keep them inside the ecosystem. And that brings us to the hub of this whole thing, a doctor named Clifton Burt and his clinic, Premier Pain and Rehab.
Okay, this is where it gets kind of shocking. You know, you'd think people committing fraud would try to be a little sneaky.
You would think.
But Uber and FedEx found emails sent from an address literally named Medical Simon Law Firm at gmail.com.
You almost have to appreciate the directness. Subtlety was not the priority here.
So Medical Simon Law Firm is emailing Dr. Burt's clinic. Now, normally a lawyer might say, hey, my client's back hurts, can you evaluate them?
That would be the ethical thing to do, yes. But these emails were directives. They weren't asking for an opinion. They were ordering off a menu. The emails would list like 10 clients a day and tell the doctor exactly what to do.
Before the doctor had even seen the patient.
Before the exam. That's the core of it. The complaint shows an email with a patient's name and right next to it, the acronym LSPRFA.
Which is lumbar, spine, radiofrequency ablation.
Yeah.
And just so we're all clear, what is that? It sounds intense.
It is not a massage. It is a procedure where a doctor puts a large needle in your back, guides it to a nerve, and uses radio waves to heat the tip and burn the nerve tissue.
And burn the nerve.
They destroy it to stop pain signals. It's invasive, it's painful, it's permanent.
And the lawyers are allegedly just ordering this up via Gmail. Do this to client A, client B.
That is the allegation. But here's the catch, and this is where the simulation part really comes in. Medically, you can't just jump to burning a nerve.
Right, there has to be a protocol.
There is. You have to do a test run first. It's called a medial branch block.
A dress rehearsal.
Sort of. The logic is simple. Before you burn a nerve, you want to be sure it's the right one. So you inject a numbing agent like Novocaine onto the nerve.
Okay.
And then, this is the crucial part, you wake the patient up, you send them out, you have them walk around. If they feel significant pain relief, like 80% or more, then you know you've found the right spot.
Inject. Wait. Verify. Then you schedule the actual burn for another day.
Exactly. But Dr. Burt's records showed a pattern that, well, that the lawsuit says is medically impossible. First, his notes were all identical. Every patient, he wrote, had 40% improvement for 20 minutes.
Wait, 40%. You just said the standard is 80%.
It is, and 20 minutes is very short. But the notes aren't even the smoking gun. The clock is.
What do you mean?
They looked at the metadata on the digital x-rays. You use x-rays to guide the needle, and those files have timestamps you can't fake.
Oh, wow.
And the time between the last x-ray of the test injection and the first x-ray of the nerve burn was impossibly short. We're talking 90 seconds, 2 minutes.
That's it.
In some cases, it was 34 seconds.
34 seconds.
34.
Hold on. So the patient is on the table. You do the test shot. You're supposed to wait for it to work. Get them up. Assess their pain.
There's no physical way to do that in 34 seconds. You can't even clean the room that fast.
So what does that mean actually happened?
The complaint argues it proves the decision was made before the patient even walked in the door. The test was just for billing. Dr. Burt was allegedly doing the test and the burn back-to-back because that's what Medical Simon law firm ordered.
So the test was a simulacrum of a test.
Exactly. And people are getting their nerves burned not for medical reasons, but because a lawyer needed a specific procedure on a bill to break that limited tort threshold.
That is just profoundly disturbing.
And to get there, you need a history. You can't just go straight to burning nerves. You have to show you tried other things first. And that is where the chiropractors come in.
The supporting cast. Philadelphia Spine Associates.
Right. Their role, allegedly, was to provide the bulk, the volume. To make a case look serious, you need a thick file. So they'd have patients come in for 15, 20 visits.
And the records, again, didn't really match reality.
Total boilerplate. Cut and paste. The records claimed 15-minute massages, chiropractic adjustments, but the actual patient said, no, I just sat in a chair with electrical stimulation pads on my back.
Billing for a hands-on treatment, but the reality is sitting in a chair checking your phone.
And again, the digital footprints gave them away. Some of these records were e-signed before the appointment even happened.
So they were just auto-generating paperwork. It's industrial.
It's the conveyor belt. And that brings us to the middleman, the MRI. Almost everyone was sent to the same facility.
And even if the MRI came back clean?
Doesn't matter. Even if it showed nothing but normal aging, you needed that scan. You needed it to justify Dr. Burt's injections, and you needed it for the final piece of the puzzle. The closer.
The closer. This would be Dr. Lance Yaris.
Dr. Yaris is the expert witness, the salesman who puts the price tag on the whole thing. The complaint alleges he was paid over $3 million by Simon & Simon since 2017.
$3 million for objective opinions.
And for that money, they got consistency. The complaint alleges that in 100%, literally 100% of the cases he reviewed for the firm, he found a serious permanent injury.
It didn't matter if it was a high-speed crash or a parking lot tap?
Didn't matter. His reports used almost the exact same language every time. But the really damaging part was his recommendations for the future. He would recommend massive surgeries, laminectomies, fusions.
Stuff where they bolt your spine together.
Major life-altering operations, and he'd say they were needed within the next 5 years. Then he'd attach a life care plan to it, valued at $1 million or more.
So he writes this scary report. The insurance company sees it and thinks, if a jury believes this guy, we are on the hook for millions. Let's just settle for $500,000 and be done with it.
That's the leverage. It's fear. But here's the disconnect. When the clients actually had to testify under oath, they admitted they had no plans for surgery. Some hadn't seen a doctor in months.
So you've got a report saying imminent spinal fusion needed, and the patient is saying, I feel fine, actually.
Exactly. The complaint even quotes a federal judge, Judge McHugh. He said he had yet to see a single case where any plaintiff actually pursued the recommended care. He called the reports litigation documents.
Not medical records. They're weapons in a lawsuit.
They're designed to extract value, not guide treatment.
Let's look at some of the actual cases.
Right.
Because the case studies in the complaint are just wild.
Okay, take claimant B. This was the backing up bus case.
Right.
So she's in an Uber. A car backs into them at low speed. A light tap.
She goes to the ER. They tell her to take some ibuprofen.
Standard stuff. But then she gets on the conveyor belt. She's sent to Dr. Burt. And this is one of the cases where the metadata showed he did the nerve burn only 34 seconds after the test shot.
For a light tap. From ibuprofen to nerve destruction.
Then Dr. Yaris says she needs fusion surgery. That case actually went to trial. The defense showed all this to the jury, and they won. Full verdict for the defense.
Okay, what about claimant R, the scooter guy? This one is, I mean, it's just egregious.
It really is. He's on a scooter. A car hits him while reversing. It bent the basket on his scooter.
And he rode the scooter home, right?
He rode it 6 blocks home. But when Dr. Yaris wrote his expert report to juice the value, he wrote that the claimant was pinned under the vehicle.
Pinned.
Pinned. Totally false. But pinned supports a diagnosis of massive trauma, which supports $1 million demand.
It's just fraudulent storytelling.
Well, let's talk about the money flow, because it's not just about the final settlement. It's about how they finance the whole thing.
Debt arbitrage.
Yes, exactly. This is a key piece. Dr. Burt's clinic was allegedly paid a flat fee by a third-party litigation funder. So let's say the funder pays the doctor $3,200 for a procedure.
Okay, so the actual cost was $3,200.
Right, but the bill they generated for the lawsuit would say the cost was $15,600.
Wait, so the doctor gets paid a few grand, but the paper they show the jury says the patient owes almost $16,000.
That's it. It inflates the damages to scare the jury. And it allows the law firm and the funders to take a bigger piece of the settlement to pay off that fake debt. It's like buying debt cheap and selling it at a 400% markup.
Pure leverage.
And that's how they could demand huge settlements for minor accidents. But Uber and FedEx have resources. They started noticing these patterns.
So what happened when they started to fight back?
This is what the complaint calls the run. When Uber started figuring out the timestamp issue with Dr. Burt, they issued subpoenas. They wanted to depose him.
They wanted to put him under oath and ask, "Doctor, explain the 34-second surgery."
And immediately, Simon and Simon dropped Uber from nearly 30 pending lawsuits.
And just walked away from the cases.
Dropped them. To avoid discovery, they sacrificed the cases to protect the machine. Because if the doctor testifies and he crumbles, the whole thing is exposed.
That is so incredibly suspicious. If my claim is real, I want the defense to talk to my doctor.
Of course. And that behavior is what triggered the ICO filing. Uber and FedEx realized they couldn't fight this one case at a time. It was whack-a-mole.
So they had to go nuclear.
Yeah.
They used RICO to say, this isn't just one bad case, this is a pattern of racketeering activity.
That is what RICO is designed for. It lets them bundle all these separate acts, the 34-second surgeries, the copy-pasted records, the expert reports, into one massive allegation of organized fraud.
So let's bring this all home for the person listening who's thinking, well, I'm not Uber, why do I care?
Because you pay for it.
Insurance premiums.
It's just basic economics. Every time a fender bender settles for $500,000 because of fake records, that money has to come from somewhere. The insurance companies pass it on to you, your premiums go up.
It's a hidden tax.
It is, and it clogs up the courts. People with real, catastrophic injuries are stuck in line behind thousands of these manufactured claims. It hurts everyone.
It's a grim picture. You have lawyers allegedly practicing medicine and doctors selling their signatures.
And we should remember, these are allegations. Simon and Simon will get their day in court. But the evidence that's attached to this complaint, the emails, the timestamps, it's very specific. It's going to be very hard to explain away.
It definitely makes you look at those no-win, no-fee billboards a little differently, doesn't it?
It certainly does.
So I want to leave you with a final thought to mull over. We've all heard of ambulance chasers, but this sounds like the ambulance is being driven by a business model. So in a world of these settlement mills, where lawsuits can be manufactured on a conveyor belt, you have to ask, how much of the medical care in a personal injury case is actually for the patient's health, and how much is just a prop to build a bigger bill for a lawyer?
That is the multi-million-dollar question.
Thanks for diving deep with us today. Check your medical records, folks.
Indeed. Stay curious.